Hey guys, I'm gonna have to work through this kind of as fast as I can because I got to start work soon. But it's only like 30 some pages and we can skim over some of it. So we should be able to do that. Let me pull this up real quick. This came out like last night. All these things started coming out in the middle of the night, and I was like, it's just too late for me to start reading something right now. So I waited till this morning. But this is their response to her motion for spoliation sanctions. Remember, she was trying to say that they intentionally deleted messages that she would have needed to like make her case because they used the Signal app and they didn't disable the auto delete function. But they did as soon as they got her notice of like a preservation notice where they knew they were actually supposed to preserve those messages. That was in December 2024 when she filed the CRD complaint and all that. But then now she's trying to kind of walk things back and say, well, no, actually, they knew they were supposed to preserve all their messages from November 2023, which doesn't even make sense, by the way, because they were still in filming and all that. And there was no like need for a crisis PR team or anything at that point in time. They had no idea a lawsuit was going to happen. Like, I don't know, just all kinds of, crazy shit. But this is their response to that, telling the judge why they think that she should not be able to get these harsh sanctions that she's asking for. So she's asking for them not to be able to, well, not just with this, though, mind you. It was with the Jamie Heath birthing video, too, the Melissa Nathan redactions, which the judge denied. She's asking basically for the jury to, take these things as and like what she's saying is true, and the Wayfarer parties cannot testify to these things, and just all kinds of crazy stuff. Like, I don't know. Okay, we'll get into it, and they'll explain it in this because like I said, I have to kind of work through this pretty quickly this morning, so I won't waste too much more time. Hang on. Okay. There we go. That should be readable for you guys. All right. Let me turn my camera off for this because it was playing up this morning, and if it's going to cut in and out, it'll just be distracting. Okay. Lively seeks the most severe sanctions available under Rule 37E, including an adverse inference that an August 2024 crisis management strategy was not only planned but executed, and a preclusion order barring defendants from presenting any evidence refuting Lively's claim that they executed on the plan to manipulate the internet to defame Lively and derail her career, for which she is now seeking a mere $300 million in damages. Lively's showing falls woefully short of the harsh standard for sanctions under Rule 37E2, or even the lesser sanctions available under Rule 37E1. Boiled down to its essence, the motion asserts that some defendants may have used Signal to discuss topics relevant to this litigation prior to the December 20th, 2024 filing of Lively's complaint without disabling the auto-delete feature. Lively assumes and asks the court to assume that all 8 defendants deleted messages that might have further shown that defendants executed on a crisis management strategy that turned the internet against Lively in August 2024. At the time of the film, It Ends With Us was released. The mere assumption that some or all defendants may have deleted relevant evidence, even intentionally, is not enough to justify sanctions that would devastate the defense of 8 defendants. The motion's first flaw is that Lively seeks blanket sanctions against all defendants without distinction. Rule 37E sanctions are personal and cannot be awarded against a group of 8 without proof that each independently spoliated evidence. Lively fails to show that any message evidencing the implementation of a smear campaign was deleted by a particular defendant, or even that all defendants used Signal to communicate about Lively prior to the filing of her complaint. Rather, Lively indiscriminately seeks sanctions against all 8 defendants. And she's up to what? 9 sanctions motions now, which is crazy. Hey, Donna, what's going on? Wait, oh my god, it's so early where you are. Why are you awake? What now? No, this is just a response to one of her sanctions motions. Though she did last night also, and we're not going to go over that this morning, but she also asked last night that basically the Wayfarer parties not be able to object somehow to like admission of some things, I think it was. don't know. I watched Brit did a like really good short video on that. You guys should check it out, and I'll go over it later. But there were like 527 things, and she basically is like, oh, okay, so it was like authenticating things, right? So can you like verify, I guess, that you created this document or whatever? And then she's saying because all 8 of them would not be able to answer for, one thing, that thing should be just like taken as verified. But we'll go over that later because that's going to get confusing if we get into that now. Yeah. Okay, one sec. I gotta get some water real quick. It's right here. I'm not going to leave the room. Just give me a second. Feel like I have to turn the camera on when I'm drinking, otherwise you guys will think that I just like got lost or something, or I'm pulling in Omar and I forgot to unmute myself. Okay. Plaintiff admits that it is unclear whether all defendants used Signal prior to December 20th. The allegation that all defendants executed a crisis management strategy to manipulate the internet is based solely on the supposition that negative publicity about Lively went viral in August 2024, and thus defendants must have been the cause. And I think we know that's not true. In fact, Lively fails to identify specific communications that might demonstrate the implementation of the digital campaign. She only speculates that such evidence may or must have existed and have been automatically deleted. So she doesn't like prove that there was any evidence that was removed. She's just like, well, no, there must have been some evidence to prove that what I'm saying is true. My crazy, weird, paranoid conspiracy theory is true. But it must have gotten deleted, but without any evidence to support that theory. Like anyone could say that. Basically, if you get proven wrong on something, well, no, this must have just been deleted. You're just supposed to take my word for it. You know what I mean? Oh God, damn, this lady's crazy. All right. In fact, Lively fails to identify specific communications that might demonstrate the implementation of the digital campaign. She only speculates that evidence may or must have existed and been automatically deleted. Lively stubbornly refuses to acknowledge or take any responsibility for her own conduct, which was the impetus for the public backlash that spiraled out of control when the film was released in August 2024. Yeah. And it's not hard to see how that's true, given her behavior since the lawsuit started and her going after 107 creators because she didn't like what they said about her. You know what I mean? Like, Jesus. She did that all to herself. It is not difficult to understand how this lady might have blown up her own reputation and then made it infinitely worse by trying to blame it on someone else. All right. Lively also fails to make the critical threshold showing for application of Rule 37E, namely that any defendant anticipated litigation over a smear campaign, the purported subject of the allegedly deleted communications, and thus had a duty to preserve such evidence prior to the filing of Lively's December 20th complaint. Because that doesn't even make any sense, because Melissa Nathan wasn't even in the picture at that point, right? Neither was, Jed Wallace, who's now been dismissed from the lawsuit for the second time. So, yeah. Lively's claims fall into 2 categories. 1, claims relating to alleged sexual harassment and gender discrimination by certain Wayfarer defendants occurring between May 15th and June 14th, 2023. And 2, claims related to an alleged digital or smear campaign that allegedly began in August 2024. Okay. The signal messages that are the subject of plaintiff's motion relate to the digital or smear campaign allegedly conceived in August 2024, not Lively's sexual harassment claims. Plaintiff does not even attempt to show that any party contemplated litigation over a public relations strategy or digital campaign when unspecified signal messages allegedly were deleted by any defendant. Right, so any of this supposedly deleted evidence, which we all know that's not a thing, but any of this supposedly deleted evidence wouldn't really matter, even if they had, had messages that were auto-deleted, because none of it would have been about a PR campaign, a smear campaign, because there was no crisis PR involved at the time. Okay. Plaintiff merely points to a November 9th, 2023 demand letter relating to the objections she raised in 2023, and that was, the 17-point list, right? And defendant's discovery response, which confirmed that in November 2023, they anticipated litigation in connection with the shooting of the film in May and June 2023. Lively fails to demonstrate that defendants reasonably foresaw litigation in which the August to December 2024 signal chats might be relevant, and thus fails to establish a duty to preserve those messages. Okay. Lively next fails to show prejudice caused by the acts of any defendant, a predicate for Rule 37E sanctions. In fact, plaintiff fails to show prejudice at all. Lively contends that severe prejudice is obvious because deleted signal messages may have further shown defendants' execution of the digital campaign, thereby impairing Ms. Lively's ability to fully prosecute her claims and rebut the defense that the Wallace defendants decided, after being retained, that no proactive digital campaign work was required given organic online sentiment. Yet on the very first page of her motion, plaintiff admits that she was not prejudiced by the deletion of signal threads by noting that despite defendants' alleged efforts to cover their tracks, there is substantial evidence, that the retaliatory campaign was, in fact, implemented as planned. Lively has also produced multiple expert reports which rely on the evidence she provided to opine, albeit erroneously, on the execution of the digital campaign. Since she admittedly has substantial evidence that the digital campaign was implemented, Lively cannot establish prejudice from the purported denial of further evidence, which may be subject to exclusion as cumulative. Absent a showing of prejudice, plaintiff is not entitled to sanctions under 37E. Lively thus fails to establish her right to sanctions, which, upon a showing of prejudice, are limited to those sufficient to cure the prejudice she has not shown. But Lively does not seek sanctions under subsection E1. She seeks the more severe sanctions of an adverse inference and preclusion available only under 37E2. Failing to meet her burden under 37E1, she is not entitled to sanctions under E2. Even assuming she met her burden under E1, Lively fails to establish that any defendant acted with the intent to deprive her of specific evidence for use in this litigation, a predicate for the onerous sanctions available under subsection E2 only. Okay. As elaborated below, conjecture and speculation are insufficient to justify sanctions under 37E, much less the severe sanctions of an adverse inference and presumption that damaging evidence existed and was deleted. In fact, this is only one of multiple sanctions motions in which Lively, implicitly conceding that the evidence adduced in discovery will not support her claims, seeks to exclude evidence crucial to the defense. Right. Crippling the defense of 8 defendants to avoid having to prove claims with admissible evidence is not a proper purpose of Rule 37E. Okay. One sec. Okay, let me read the footnote here before we get into the background. Plaintiff devotes much time to arguing that defendants were too slow in producing documents or otherwise engaged in efforts to obstruct discovery. Defendants deny these accusations. Most importantly, perceived shortcomings in defendants' discovery efforts are not relevant to a 37E analysis, as the court cannot impose sanctions for spoliation of ESI pursuant to its inherent powers. Okay. All right, so we get into the factual background here. Give me 1 second. I don't know how much of this I wanted to skim over. Let me swap over to the highlighted version. Okay. You can see, like, I basically highlighted, like, the entire page on some of these, but, that's just how it goes when I try to highlight things. I'm not very good at shortcutting. Okay. Plaintiff asserts claims for sexual harassment and retaliation under FIHA and Title VII, as well as defamation and other reputational harm against defendants. I'm just going to say the Wayfarer parties. Plaintiff also complains that Wayfarer's public relations/crisis management team, Jen Abel, Melissa Nathan, and Tag, were involved in an alleged digital campaign that manipulated negative content against Lively on the internet. The relevant facts are summarized below. Okay. During phase 1, Lively complained about purported mistreatment on the set by Baldoni and Heath, including alleged conduct that made her uncomfortable. Her complaints ranged from wardrobe and scheduling issues to Baldoni's statements that she looked hot or sexy in costume designed for an intimate scene between Baldoni's and Lively's characters, and Heath showing her a video of his wife after the birth of his daughter in connection with the filming of a birthing scene. It sounds ridiculous. Lively did not file a formal complaint, but voiced concerns to Baldoni, Heath, and others including the film's distributor, Sony. Okay. During the strike-related pause in filming, the Wayfarer defendants received a letter from Lively's lawyer, Lindsay Strasberg, demanding that Wayfarer agree to a 17-point list of protections as a condition for Lively's return to complete the film. The letter stated, if the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. So this line right here is what she's trying to argue was some sort of preservation notice. Like they were supposed to see that and know that they were supposed to disable auto-delete on Signal and save all their communications based on this right here, which is, in my opinion, kind of stupid. It doesn't really say we're going to sue you or anything like that. It says if you're unwilling to accept these protections, then, we might decide to pursue other options, which, as we know, they did feel pressured to sign off on that, and they did. So there was no reason to think that there was any lingering issue or that there could be a lawsuit over it at that time. That's just my opinion. All right. Under extreme financial pressure to complete the film and pressure from Sony, the film's co-investor, Wayfarer, agreed to the protections. The Wayfarer defendants understood that their agreement to the protections, right, like I was just saying, resolved the issue that had arisen during phase 1 and eliminated the threat of potential litigation. Filming resumed on January 5th, 2024, following an extremely tense all-hands meeting on January 4th, 2024, in which Lively's husband, Ryan Reynolds, spent hours berating the Wayfarer defendants for their conduct. I am going to sneeze. Give me one sec. Nope, the moment passed. Okay. Sorry. After returning to set, Lively did not assert any further complaints. There was no evidence or even allegation that the Wayfarer parties failed to uphold the protections during the second phase of filming. The PR defendants were not parties to the protections, did not attend the January 4th all-hands meeting, and did not have any contact with Lively about her complaints of misconduct in phase 1. Okay. During the second phase of production, Lively moved to seize control of the production. Among other things, she wrested control over editing, post-production, and marketing from Baldoni and Wayfarer. Ultimately, Lively gained control over the entire post-production process. Right, we knew that. Let's see. Lively accomplished her takeover through threats that if her demands were not met, she would not participate in marketing the film, even though she was contractually obligated to do so. So she still wasn't even threatening legal recourse at that point. Okay. Not content with usurping Baldoni's role as director and excluding him from the marketing of the film he developed, financed, directed, and starred in, Lively then sidelined, indeed banished Baldoni from the premiere, refusing to be photographed with him and demanding that he and his guests be hidden from sight and shunning Baldoni and his guests into another screening room. If you guys don't remember, there were actually photos of that. So you can see him and his guests in a, what people call it, a basement. I don't know if it was actually a basement. I don't remember at this point. I think it was, though. Okay. Baldoni was also barred from appearing with Lively in publicity photos or promotional appearances. Lively very publicly unfollowed Baldoni on social media. Right. Okay. By the time of the film's August 6th premiere, rumors of discord on the film's set were already swirling on social media and in the press. These rumors were fueled by, and then we have a lot of redactions here, but you can kind of guess what was there based on these next sentences. Lively's unfollowing of Baldoni on social media, and Lively's insistence that Baldoni be stripped of the credit film by Justin Baldoni on the movie he developed, sold, directed, and starred in. Lively was also, and then this is redacted, but the next part says, the decision was particularly tone deaf given the role of alcohol abuse in domestic violence cases. Nevertheless, Lively used alcoholic drinks using her Betty Boo's alcohol products, such as Ral You Wait, and it ends with Buzz, at promotional events. The public backlash was immediate and unforgiving, which is basically what they've been trying to say the whole time. Like, she fucked this up so bad that the public turned on her, and they didn't have to do anything, really, in terms of like their crisis PR plan. Like, they did the social media monitoring, they maybe did some defensive stuff, but there was like the stuff she's accusing them of doing. No, they didn't have to do that because she fucked it up all on her own, like tremendously. It was so bad. Ugh. All right. Given the circumstances and Lively's affirmatively hostile conduct, the Wayfarer parties were understandably concerned about a potential onslaught of negative publicity from Lively. On July 25th, they contacted Melissa Nathan and Tag to defuse and defend against Lively's anticipated assault and protect the film and Baldoni's professional reputation as a producer and director. They also retained Jed Wallace to provide digital monitoring services. On August 2nd, the crisis management / public relations team circulated a scenario planning document with a proposed strategy to counter against negative press and Lively's effort to disparage Baldoni and Heath as the film director and producer respectively, tamp down the growing chatter on the internet's rumor mill, and handle the response should Lively and her team make her grievances public. Okay. Lively defines this defensive measure as the launch of a retaliatory smear campaign and contends that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. In fact, the Wayfarer defendants did nothing other than exercise their right to defend against Lively's attacks and the tidal wave of negative publicity triggered by Lively's conduct. Lively implicitly concedes that the goal of the Wayfarer defendants' public relations effort was not in retaliation for some protected activity, but to defend Baldoni and his reputation. Right. One sec. All right. The strategy described in the scenario planning document was never implemented. Anti-Lively, pro-Baldoni sentiment went viral organically. Plaintiff's own timeline indicates that defendants could not have been the masterminds behind the spike and negative publicity. Sorry about that. That is my alarm reminding me of something. Let me make sure that doesn't go off again. One sec. The allegation that all defendants executed a crisis management strategy. Stop that. Sorry. Okay, there we go. I got it. Plaintiff's own timeline indicates that defendants could not have been the masterminds. She points to spikes in negative internet traffic on August 8th and August 14th. Okay. The first spike in negative digital coverage began on August 8th, before Wallace, the alleged digital wizard, was retained, and only one day after he was referred by Nathan. Even looking at the August 14th spike, plaintiff does not offer any explanation about how the PR defendants and Wallace were able to turn the entire internet against Lively in less than 2 days. No. Turning the entire internet against Lively in less than 2 days is a feat that only Blake Lively can apparently accomplish. So, okay. These facts undermine Lively's presumption that defendants manipulated the spike in the already burgeoning negative sentiment targeted at Lively. Okay. Here we get into the use of Signal by some of the defendants. After the crisis management team was brought on board, and prior to plaintiff's filing of her claim on December 20th, certain defendants used Signal chats to communicate. Signal is a commonly used app which provides enhanced security features, right? So some government agencies actually use Signal. Lots of people use Signal for business. It's not a shock. Like, this isn't some weird nefarious thing, All right. Sarwitz, Baldoni, and Abel did not use Signal at all during the pre-litigation period to communicate about Lively. And yet she's trying to say that they deleted messages on Signal when they actually don't even have any. They never even had any. They didn't exist, right? However, to the extent Signal was used, the participants had Signal set on its auto-delete feature. However, the defendants also used traditional platforms such as text messages to communicate about Lively. These messages have been produced, and some of these messages may be included in the substantial evidence Lively claims exists. And then we got a footnote down here that says, for instance, Lively cites to the June 2024 message in which Abel discusses whether to recommend Brian Friedman. And in August 2024, Katie Case indicated they were getting ready to go to war. Okay. Plaintiff filed her CRD complaint on December 20th and on the same day sent a cease and desist advising the parties of a litigation hold. The engagement letter cautioned defendants to preserve documents. Shortly thereafter, defendants switched off the auto delete feature. So as soon as they were as soon as they were notified, they did switch off the auto delete function. So non-privileged Signal communications after December 20th have been produced. Right. A party seeking sanctions for spoliation has the burden to establish, one, that the party having control over the evidence had an obligation to preserve it at the time it was destroyed. Two, the evidence was destroyed with a culpable state of mind. And three, the destroyed evidence was relevant to the party's claim or defense, such that a reasonable trier of fact could find it would support that claim or defense. Okay. There are two levels of sanctions under Rule 37E. So E1 are available upon a showing of prejudice and are limited to measures no greater than necessary to cure the prejudice. Right? More severe sanctions, including an adverse inference, presumption, and terminating sanctions, are available only under 37E2, which requires an additional showing that the spoliating party deleted or destroyed evidence with the intent to deprive the non-spoliating party of its use in the litigation. As a preliminary matter, Rule 37E sanctions are personal, and the destruction of documents by one party cannot give rise to a spoliation sanction against another party. Plaintiff does not identify which of the 8 defendants may have used Signal and deleted specific items of relevant evidence. She merely asserts in the most conclusory fashion that there is no dispute that each of the defendants used Signal as an ephemeral messaging platform to discuss issues related to this litigation. Okay. All right. There may be no dispute that some defendants use Signal. There is certainly a dispute over whether all defendants use Signal and whether any defendant deleted messages evidencing the execution of a planned digital campaign. In fact, there is no evidence that most defendants used Signal prior to December 20th, much less used it to communicate about this litigation or deleted relevant evidence. Plaintiff concedes that the pre-litigation Signal threads relating to Lively were used primarily by Nathan and Wallace and admits that it is unclear whether Mr. Baldoni and Mr. Sarowitz were separately using Signal prior to December 20th. Baldoni also did not use Signal prior to December 20th to communicate about Lively, but only used it in connection with the men's support group unrelated to Lively or this action. Heath downloaded Signal in August 2024 and briefly connected with Wallace. There is no evidence that Heath's handful of messages, evidence, or even reference the implementation of a plan to manipulate the internet to ramp up negative publicity about Lively. Abel did not use Signal prior to Lively's filing of her complaints, except for communications relating to another very high-profile client unrelated to this action. In sum, plaintiff fails to show that a particular defendant used Signal during the pre-litigation period, much less deleted evidence that defendants' public relations strategies outlined in the scenario planning document were put in motion. Yet the blanket sanctions sought by plaintiff would effectively strip all 8 defendants of any ability to defend against her retaliation and defamation claims. Okay. To even establish that Rule 37E applies, a party seeking spoliation sanctions must show that the destroying party had an obligation to preserve the evidence at the time it was destroyed. Okay. Plaintiff contends that Strasbourg's November 9th demand letter placed the Wayfarer defendants on notice of potential litigation and that the evidence was relevant to litigation. Okay. Plaintiff also cites defendants' interrogatory responses, which acknowledge that the Wayfarer defendants recognize the possibility of litigation relating to the shooting of the film. Right. So no retaliatory smear campaign or anything like that related to the shooting of the film in or around mid-August 2024. Okay. In other words, the only litigation that could have been anticipated involved Lively's objections in phase 1. Right. However, Lively's motion is based on the premise that allegedly deleted signal threads may have been relevant to the execution of the digital campaign, not Lively's claims of harassment or discrimination during phase 1 of shooting. Plaintiff provides no support for the allegation that any party contemplated litigation over a PR strategy or digital campaign when signal messages were deleted. And naturally, naturally, Lively does not explain how any defendant could not have reasonably foreseen litigation in November 2023 over a retaliatory smear campaign that did not happen until August 2024, almost a year later. In fact, even the threat of litigation over Lively's harassment allegations dissipated when the Wayfarer defendants agreed to the protections, which was the express condition for avoiding litigation. Finally, Lively identifies Nathan as the most frequent user of Signal. Nathan was retained in August 2024 as a crisis manager. Okay. There's no evidence that prior to December 20th, Nathan had reason to anticipate litigation involving her crisis management activities on behalf of the Wayfarer parties. Yep. So they hired her because they were assuming there was going to be backlash over what happened during filming. Of course, they didn't assume there was going to be a potential lawsuit over crisis PR that had not happened yet. I mean, what the fuck? Nathan was not involved with Wayfarer in 2023, and there's no evidence that she knew of Strasbourg's November 9th letter or even the nature of Lively's complaints. Plaintiff cites not a whit of evidence that the war was in any way linked to Lively's discrimination claims. Okay. In other words, there's no evidence that Nathan and Tag could have reasonably foreseen litigation, giving rise to a duty to preserve evidence when their signal messages were deleted. Okay. Rule 37E requires a showing that evidence existed and was destroyed, right? An assumption or speculation that allegedly deleted relevant evidence existed is not sufficient, right? Well, her entire case is assumption and speculation as far as the defamation claims go. Plaintiff glosses over this technicality, asking this court to assume that defendants deleted signal chats evidencing that they executed the PR / crisis management strategy. Such assumptions based solely on speculation are insufficient to justify 37E sanctions. A showing of prejudice is crucial to a spoliation analysis under 37E. Plaintiff contends that deleted communications may have further shown defendants' execution of the digital campaign, and thus severe prejudice is obvious because relevant communications were deleted, impairing her ability to fully prosecute her claims and rebut the defense that the strategy for a proactive digital campaign was abandoned because of organic flood of negative internet activity spawned by Lively's own conduct. God. The fact that they have to continuously point this out is like... I feel bad for these guys. All right. Shannon Connolly, thank you for the $20. Happy belated birthday, Lauren. Thank you very much. I appreciate that. I don't like getting older, but it is what it is, I suppose. All right. Lively herself rebuffs the notion of prejudice on the very first page of her motion, admitting that despite defendants' efforts to cover their tracks, there is substantial evidence that the allegedly retaliatory digital campaign was implemented as planned. We'll see about that. Okay. Lively fails to explain why, if she already has substantial evidence, the lack of further evidence prejudices her ability to prove her claim. In fact, district courts routinely exclude relevant evidence that is needlessly cumulative. As shown above, plaintiff fails to show that defendants or any of them violated Rule 37E, much less that she was prejudiced by a deletion of relevant signal messages. Accordingly, plaintiff is not entitled to reasonable attorney's fees to cure any imagined prejudice. Okay. Plaintiff fails to show that any defendant had a culpable state of mind when signal messages automatically deleted. Plaintiff concedes that the signal auto-delete feature was disabled after litigation commenced, and defendants have produced post-filing signal messages. These facts weigh heavily against the notion that in using signal and its auto-delete, defendants acted with culpable intent to delete relevant evidence. Okay. Rule 37E2 provides for more severe sanctions, including adverse inference and preclusion. Plaintiff seeks an adverse inference and preclusion order establishing that allegedly lost ESI was unfavorable to plaintiff and barring defendants from presenting any evidence to support their defense that the strategies set forth in the scenario planning document were never executed. Such an order would conveniently relieve Lively of the burden of having to prove her claims with admissible evidence, something discovery has shown she cannot do. That's not surprising. The more severe sanctions available only under Rule 37E2 require a showing that the spoliating party intended to deprive the moving party of information for use in the litigation. Okay. Plaintiff fails to meet any prong of the intent to deprive test. First, as shown in Section 3C above, Lively fails to show that relevant evidence existed. Plaintiff only speculates that the deleted chats may have included evidence that defendants executed on a plan to manipulate internet traffic. Second, plaintiff does not show that defendants engaged in an affirmative act causing the evidence to be lost. Okay. Third, addressed in Section 3B above, Lively fails to show that any defendant deleted relevant signal chats knowing of a duty to preserve all the evidence. Finally, the use of auto-delete can be credibly explained. At the time the crisis management strategy was developed, the internet was already ablaze with stories about the Lively-Baldoni dispute, triggered primarily by Lively's conduct and excluding Baldoni from the marketing of the film and the premiere, Lively's unfollowing of Baldoni on social media, and Lively's own missteps in the marketing of the film. Surely even plaintiff would admit that keeping crisis management communications confidential and safe from hackers and aggressive media players can be credibly explained as not involving bad faith by the reason proffered by the spoliator. Okay. So that was about all I wanted to go through on that. Let's see. Yeah. For the foregoing reasons, defendants respectfully request that the court enter an order denying Lively's motion for Rule 37E sanctions in its entirety. All right. Okay. There are some exhibits that go with that. I did skim over them. It looks like it's nothing like groundbreaking in terms of things that we already knew. If anything in there when I go over it again is like, something that needs to be looked at further, I'll definitely do that. But I do have to get to work now, guys. So I will see you guys later. Thank you for watching. Okay. Bye.